The most consequential abortion rights and healthcare case since the earthquake that was Dobbs was before the United States Supreme Court today, and oral arguments focused on whether it should have been before the justices at all. The case challenging the availability of the abortion drug mifepristone began in Amarillo, Texas, of all places, because anti-abortion activists thought a federal judge there would be receptive to their claims. And he was. But today it was met with deep skepticism from even the conservative wing of the Supreme Court, who seemed disinclined to side, based on what we heard, with the far-right organizations seeking to curb access of this FDA-approved drug. Questions about whether the plaintiffs should be able to bring the case at all surfaced early in oral arguments. Here's Justice Kagan.
Can I just ask a quick question about the merits? You open your brief with a somewhat arresting statement. To the government's knowledge, this case marks the first time, and I'm going to say, is it the first time? Is it the only time? Any court has restricted access to an FDA-approved drug by second-guessing FDA's expert judgment about the conditions required to assure that drug's safe use. Is it still the only time?
That is still, to our knowledge, the only time a court has done that.
Only time, ever. Justice Kagan's doubts that the anti-abortion doctors who brought the suit do not have the standing to do so was echoed, oddly maybe, by Justice Neil Gorsuch, who pointed out that the Supreme Court has never issued the kind of injunction that the anti-abortion activists are seeking, a point that was also highlighted by Justice Ketanji Brown Jackson.
I'm worried that there is a significant mismatch in this case between the claimed injury and the remedy that's being sought. They're saying because we object to having to be forced to participate in this procedure, we're seeking an order preventing anyone from having access to these drugs at all. And I guess I'm just trying to understand how they could possibly be entitled to that, given the injury that they have alleged.
I agree, Justice Jackson, and I do think it's relevant to standing. There's a profound mismatch here between the claimed injury and the remedy. The relief that they're seeking would dramatically alter the approved conditions of use for mifepristone and affect women all around the nation.
All of us, everywhere. Justice Jackson referencing this broad impact that it would have on women's access to reproductive health care. A recent study finding that medication abortions, like those that rely on mifepristone, account for the vast majority, 63%, of all procedures. Now, given the weak legal pretext in bringing this case at all, if the justices side with those seeking to limit access to mifepristone, it has the potential to further erode any remaining public trust in the nation's highest court. It could also open the door to challenging any other drug that's FDA approved that anyone has any political or moral objection to, including birth control, fertility drugs, vaccines, completely disrupting access to health care and drugs that every American is now used to and relies on. Joining our coverage, senior editor for Slate and host of the Amicus podcast, Dahlia Lithwick, is with us. Also joining us, MSNBC medical contributor, Dr. Kavita Patel. Claire is still with us. Dahlia, what did we learn today?
Yeah, I think we learned that almost completely across the partisan, political, ideological board, this was a dumb case, that there was just no plausible claim to standing, that the claim to standing that these physicians had lashed themselves to was this notion that not that they ever have to give mifepristone, but that some other doctor somewhere might give some patient mifepristone, and that patient might have an incredibly rare adverse effect, and that patient might then end up on their table, at which point they might then have to do something. And that's a causal chain that has so many might thens that they even lost, as you said, Justice Gorsuch. And it was evident, I think they even lost Clarence Thomas.
I mean, that sounds like a setup of a joke. Like, how bad was it? It was so bad they even lost Clarence Thomas. What should we infer from it? Because I don't want to overread what you're describing in terms of today's arguments, Dahlia.
I think what we infer is that this is one of a raft of deeply embarrassing cases that seem to originate in Texas and come up through the Fifth Circuit, in which these courts think that they are, in fact, the deciders. And we've seen a long pattern of these cases, including SB4, that Texas immigration bill that caused so much of a ruckus last week at the court, that there's a lot of judicial bodies out there that want to force the Supreme Court to move further and faster, and the Supreme Court doesn't seem to be having it. I think the other thing we can infer, and this is the scary bit, is that we had at least 2 justices who were kind of chomping at the bit to talk about the Comstock Act, which is an anti-vice law that's 120 some years old, and that if they had their druthers, we could see a future case in the not so distant future in which that law, which was, as I said, an anti-pornography, anti-obscenity law that's been defunct for 100 years, could be trotted out in the near future to do away with abortion, not just pills in the mail, but abortion nationwide for everyone. That's pretty chilling that that's even a conversation that's being had.
So, Dahlia, I just want to make sure I understand your expert analysis. It's not that the court softened its view on abortion. It's that they questioned the specifics of this case belonging before the court. It doesn't necessarily mean mifepristone is safe forever. It just means, or tell me if I have that right.
No, that's exactly right. And I think we heard smatterings of the justices, some of the conservative justices saying, hey, come back when you've got a state plaintiff and, as opposed to one of these kind of grumpy doctors, and we might entertain this. Come back when you've got it tethered to the Comstock Act, and we might entertain it. Come back when, things are a little more settled, when Donald Trump is elected and the Comstock Act becomes the law of the land, and we might entertain it. I didn't see this necessarily as a sort of closing of the gates on a mifepristone challenge. I saw it as the opening of a lot of really scary Overton windows for the future.
Yeah. Thank you for that. First of all, for just calling it a dumb case was really more clear and clarifying than any analysis that I'd read all day. I guess, Dr. Patel, what I wanted to come back to you on is this incredible moment where we're covering the legal and political fallout from a right that American women have had for 50 years. It was so set in the minds of voters and families and men and women that it wasn't even a real voting issue anymore, right? People took it for granted. And I know it was vexing to the women who fought for that right to begin with. Has now been taken away. And regardless of what happened in court today from what Dahlia expertly called a dumb case, access to health care, access to reproductive health care, access to contraception, access to abortion health care is still very much at risk in our country.
Yeah, it's at risk not just in the 14 states that have made it just incredibly hard to non-existent, but to the rest of the country. I mean, we've seen, you mentioned the 63% who've been receiving medication abortions, which is a significant increase from before. That's just a reflection of people are going to neighboring states and places. But even in those neighboring states, Nicole, it's not as if we've just had clinics and doctors sitting around doing nothing. This is on an already pretty stressed system. And we've talked about how doctors like me are pretty risk averse. We don't like it when there's kind of what seems like kind of confusing legal territory. So all this has done, even though that it feels like one step forward in some ways on this legal standing issue. And I've learned a lot more law than I ever thought I would need to, even having worked on the Hill and just the last day alone. I think that this has created enough doubt even in prescribers' minds where they're thinking, well, do I really want to do this? Because somehow I could be tied to some sort of liability. And sadly, that's where we're at right now. So this is real healthcare being compromised in real time. And it's leaving not just women, it's leaving households. Remember, a majority of the people who seek abortions and seek early termination in pregnancy already have children. These are people with full-time jobs. These are people that we know depend on healthcare and people like me to deliver that healthcare without the politics, without the legal scrutiny. But that has now since entered. And I just want to say one more thing, since I'm a policy person. All we need is an FDA commissioner appointed by Donald Trump that puts into place severe access restriction, Nicole. You don't need another court case. We could see this unfold very soon with a different kind of FDA commissioner. That's all it takes to change this access.
I wanted.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.